Good afternoon. May it please the court, Alan Perlman on behalf of the appellant Lawson Financial. I am joined today by my client's principals, Mr. and Mrs. Lawson behind me. And through me, they're asking for the court to correct the deceit that took place so that the parties who game the system below are not rewarded, or in the alternative, that they at least have a fair fight. So, as your honors are aware, this case involves an arbitration with respect to the purchase of an interest in an LLC. That interest was referred to as a tenant in common, or a TIC. What's interesting is the purchaser of that TIC was not the claimant in the arbitration. It was an entity referred to as NNN9. That entity, NNN9, was in turn owned by the claimant. The claimant is a trust. The sole member at the time in 2006 was Mr. Herding Sr. Now, in 2008, that changed. In 2008, because of the passing of Mr. Herding, the interests that the claimant owned in NNN9 were completely terminated. And instead, the membership in interests in NNN9 went to his heirs. 6 children equally divided. This is uncontroverted. There is no contrary evidence. It is undisputed. So now that's 2008, January 2008. Now, despite those facts, and despite that there's absolutely no privity, no pecuniary interest, and all the rights have been terminated, yet in 2014, the claimant files an arbitration action. There was 2 days of hearing. There was supplemental briefs after the hearing, which is important, that dealt with statute of limitations, and ultimately an adverse award against my client in July of 16. We get retained, we get the transcript, and we are shocked. We have the disturbing revelation that there was improper coaching that transpired during the arbitration proceeding, whereby after the claimant's expert had testified, and on a break of that testimony, he was directed in a private caucus, as they say, to change his testimony, change the facts, and instead of testifying as an expert, basically be the puppeteer of his lawyer. And it's very critical that...
Is there record evidence that that was false testimony?
Yeah, I would say yes in both, yes in the trial court.
But there are statements that the distributions went directly to the children in 2014, correct?
Yes, but the children were not the trust.
Agreed, and
Right.
That's something that could have been cross-examined, such that the mediator would have had the opportunity to consider that in determining whether or not statute of limitations was met because of the distribution in 2014 to the children as opposed to that of the trust?
I understand Your Honor's question.
Because that to me is a really critical fact here. I in no way am pleased about the coaching, about what occurred on that tape in any way. I am looking at here the clear and convincing standard of the evidence of the fraud and the elements. That's a high burden, and the elements that are required in this particular case, such as reasonable discovery. I mean, if there's no record evidence that it's false, then where does the fraud come in?
Judge, those are fair questions, and I'm happy to hear your comments.
And again, I am very disappointed in this case.
And I apologize for not saying this earlier, but I would like to reserve 2 minutes for rebuttal. I think it's a complicated answer, so give me the latitude here. If you have, first of all, the defendants, my clients, were not in that room. They were not privy to the strategy of having the expert change deliberately to manipulate the arbitrator to write down a particular date that he said was very, very, very important, that date being 2014. Now, in the scheme of things, think about this. You have an expert on the stand for, let's say, 4 or 5 hours. He's testifying about the suitability of the investment. He's done all kinds of analysis and numbers, and then you have, of course, damages. And in the middle of all that, there's this statement of there was a distribution in 2014, and because it wasn't in a vacuum, I don't think it would be reasonable to assume that that was a product of fraud or improper coaching. But fast forward, because that's the first tranche. The second shoe to drop was after the hearing, in the post-hearing supplemental briefs. And if you were troubled by the coaching, you were going to be grossly disturbed by what happened next. Because what the post-hearing brief said was, and I quote, "Here, the investment was still viable, meaning it was not lost until 2014 when the bankruptcy case, which was filed in 2013, concluded. We know that that's not true, because this investment was over for this claimant in 2008 when his membership interests were terminated."
But you knew at the arbitration hearing that this guy's investment was done in 2008, correct?
Yes.
And you knew at the arbitration hearing that the 2014 distribution was a distribution to the heirs and not to the claimant, correct?
Mr. Schifino handled the trial. I wasn't there. I would assume that to be the case.
Well, you had the opportunity to cross-examine about the subject.
And I think that that's a fair comment. And let me say this, okay?
Mr. Perlman, I want to ask you one question that ties into that, because you're saying Mr. Schifino knew you weren't there, you can't address it. But the arbitrator on the record, where there's discussion about this, the arbitrator says, yeah, the trust didn't get that distribution in 2014, correct? No, it went into someone else's bank account.
Okay, that's not the arbitrator, that's Judge Stevens.
Is that the court? Okay.
That's Judge Stevens. And, that's another level of confusion. But I think that that's the argument that the appellees have proposed. And I find it kind of rich that ordinarily, Mr. Schifino should have presumed that when they took a break, they had hatched this plan to alter his testimony, and and I'm pretty naive, but I'm not naive enough to say that had Mr. Schifino rose and said, excuse me, what is the basis of that testimony? I'm pretty sure everyone in this room would agree. He would not have said, our lawyer is very concerned about the statute of limitations. He directed me to state 2014. He's insisting that the arbitrator write it down because it's so very, very, very important.
No, I don't think anybody is suggesting any of that. I think what people are suggesting is that perhaps it goes to whether, one, you have clearly and convincingly proved a misrepresentation, since the literal fact that was testified to was true, and the related facts that you say were not disclosed were easily uncoverable by means of cross-examination.
Right, but Judge, that came out after the fact, after the hearing. So their plan was, and it obviously worked. They get on the record a particular date, and they don't argue anything about statute of limitations. The hearing is concluded. The parties submit post-hearing briefs in arbitration. Now here it comes. Here, the investment was still viable, meaning it was not lost until 2014. That's not true. And so, in your eyes, this innocuous statement about a 2014 date, maybe, but not anymore, because now you tie it to the true agenda, which is this deceitful misrepresentation of the last act for statutes to start would have been 2014. This is not a truthful statement. No one can debate it. And it goes on. Claimants suffered actionable losses either in 13 when the foreclosure was filed or in 14 when their interests was eventually lost. That's not true. Indeed, prior to that date, claimants still owned an interest in the Aventura property, which had value. That is not true. It goes on to say, claimant initiated this case only months after being legally damaged. Impossible, absent a time machine. Impossible. And it goes on to say,
When were the bank documents submitted into evidence? The bank documents showing that the distributions occurred in 2014 to the heirs, and the 2000, I guess it would be the January 5th, 2008 final distribution to the trust. When did these documents come into our record? In other words, where were they considered? Were they considered at the mediation? Was this the foundation to the testimony of the expert?
let me say this. I know for sure that I introduced it in my trial in front of Judge Stevens. I believe it was part of the record in arbitration, but it wasn't in connection with statute of limitations. It had to do with the calculation of damages. The 2014 fake claim and how the investment was lost, etc., all came out to the blue sky, if you will, in connection with the post-hearing brief. And, you know, this has to be read in the totality of the circumstances. You know, the improper coaching to manipulate, having the expert testify to alternate facts, to get the arbitrator to write a particular date, only to circle back later and then try and convince the arbitrator that the date is 2014 on false facts. That's wrong. It's inexcusable. And the hearing, there's one element of clear and convincing fraud. I think I clearly demonstrate that. It's irrefutable. Their client conceded this, that the last distribution was in 2008 to the trust, and that all these other distributions were to the heirs, and the trust had nothing to do with this investment ever since Mr. Herding Sr.'s passing. So this was really inappropriate, if not sanctionable. This is fraud by every definition. We never really got to the second element of vacating an award because the judge was confused and urged this court to weigh in on whether or not improper coaching would be a sufficient basis ever to vacate an award. And worse than that, the court was very confused with respect to this distribution debate. There wasn't a debate about whether they got something or got nothing and who got it. That wasn't the debate, and it was lost on the judge. The debate, and it wasn't a debate because it was factually demonstrated, was that all of these were blatant lies to game the system, and you can't get rewarded. And the answer can't be, well, they got away with it, and so now we're all stuck with it. And in Mr. Schifino's defense, at the time his post-hearing brief was filed, he did not have that recording and had no idea there was an agenda that was hatched.
Why did you need the recording to argue that the statements in the post-hearing brief were inaccurate?
You don't necessarily need it, but I think it certainly would have made him realize that this is going on, because I don't know that they would have had a fact established at trial of a 2014 date. And so you can't ignore the two. They're connected. It was part of the master plan of deceit. But to your point, if the question is, well, when you get this post-hearing brief, how about then? You know, did someone sleep on their rights here? I would hope that that wouldn't be the case. I could tell you that, firstly, the hearing had concluded. And if you read the statute and the case law, it says at or prior, during the hearing. The hearing was over. So technically, I think we checked that box in terms of the statute. But that, too, is the second element that Judge Stevens didn't get to. The first is clear and convincing fraud. The second is whether or not it was discoverable by the exercise of diligence. Judge Stevens didn't rule on that. He just said that he didn't get whether or not the improper coaching would be sufficient, and he was confused about the extent of the fraud. And those were both errors on his part, respectfully. Part of that also related to the attorney-client privilege ruling, which is almost impossible to support on appeal. I don't know if the court wants me to spend any time on that, because in large part, those issues were waived. And even if Your Honors affirmed that part of the ruling, I think we still demonstrated that there was fraud in a clear and convincing manner, and we should have the opportunity to go back to complete our case, to comply with the other elements, that it related to a material issue and that it was not discoverable by the exercise of due diligence. But in any ways, going back to Mr. Schifino's defense, because Your Honor's question was fair, and you know, I think that it's also fair to presume that lawyers who file things in the state of Florida are going to comply with the rules and regulations and aren't going to be lying. I think that if the standard were you need to review everything that's submitted that day to see if someone's lying to the court, I think we're all in trouble and be a sad state of affairs for the practice of law, and we're not there. So,
on the question of the motion in limine, assuming we agree with you that privilege was the wrong basis upon which to keep this thing out, is the record sufficient for us to, is this record sufficient for?
Having
So often our iPads start playing music.
I do. Yeah, you could say that.
I think it's great, you know.
I have no idea what it's doing here. So, my apologies, Guy.
Better you than me.
Is our record sufficient for us to reach the Wiretap Act issue as a alternate ground for affirmance, or is that something that would need to go back to the trial court in the first instance?
I think it's sufficient, and I think that it's not applicable for, well, technically you may be right, because what the court did was rule strictly on attorney-client privilege. He did comment that that statute didn't apply, but the basis of the granting of the motion in limine was limited to the attorney-client privilege. Although it's interesting because in his colloquy, he did state that parts of it were waived because they were published in two pleadings in the case, and also that, you know, he suggested that we could have cross-examined, which is puzzling because that in and of itself means it wasn't privileged, okay? Because if I can ask and they're obligated to tell, it's not privileged. If I ask and it's privileged, the answer is that's privileged. And so the notion that I could have cross-examined, I think, completely eviscerates the notion that there's some type of privilege at hand.
But, so let's have one question. I think you're approaching the end of your time while you're reserving, but I think there was a statement there that says we don't need the tape, we would love to have it, but I understand your ruling. It seemed like that the conduct that occurred during that was transcribed, but the actual transcription of it was not admitted, was fleshed out and, you know, presented in the hearing itself.
That's correct. That's correct. But the judge punted to this court because he wasn't sure if improper coaching would rise to the level that would enable a court in Florida to vacate an arbitration award. And the real defect in that analysis was he didn't appreciate the fraud, and he was more thinking about, is improper coaching enough?
But on page 631 of the record, there's an admission in their pleadings that he told them to testify in a particular way.
That's right.
So what benefit does that, you know, going back and for any reason and determining the admissibility of that transcript? What does it do?
I agree. I don't know that it does much.
Thank you.
So I'm not going to wrestle there. But in
Mr. Perlman, I'll give you about 30 seconds to wrap up, and then you've got your 10 minutes for rebuttal.
Thank you. I just hope that the court would spend some time on the Bonner decision. I think the Bonner decision is virtually on point across the board. In that case, to your question, Judge, the arbitration was concluded, and there was about 25 or 27 days before the award. And the court noted, actually it's going to take me too long in 30 seconds. I'll get it on rebuttal. Thank you.
Thank you, Your Honor. My name's Eric Luden. May it please the court. My name's Eric Luden, and I represent the appellee, the Adventure Group Revocable Living Trust. First of all, I just want to respond to a couple things that I heard during the opening presentation. Anybody who knows Judge Stevens knows that he's not confused and he doesn't punt, and that's not what happened at the trial court. Judge Stevens specifically found that the private conversation that was recorded should have been excluded, number one. Number two, he heard evidence presented by Mr. Perlman about the nature of the case and decided that he can't substitute his judgment of the law for that of the arbitrator. And based on that, whether the arbitrator was right or wrong in its finding, upheld the finding of the arbitration award and denied the motion to set it aside and confirm the award. That wasn't a punt. The judge did say that he won't extend the law as it exists. He's going to follow the law, and you can take that to the second DCA if you're looking for an extension, and that's apparently why we're here. I do want to say that there were things that were said in the opening presentation that I feel compelled to respond to. Number one, there were no lies made to the arbitrator by counsel, Mr. Fittipaldi, at arbitration. Number two, he did not instruct a witness to commit perjury. He didn't do anything improper, and I understand Judge Badalamenti's, I apologize, concerns about the recording, but when you hear the recording, or when you see the recording transcribed out of context, you can't tell when an attorney is smiling, when they're joking about being kicked under the table, and when you look at it just transcribed on a piece of paper, it almost looks like sausage being made. It looks worse than it really is. And in this case, what was important to Mr. Fittipaldi was that the fact that this distribution was made in 2014 was not lost on the arbitrator, that it was critical that when they go back on the record that he mentioned that to the arbitrator, that that's when the money came out of the bankruptcy proceeding. And so he made sure to ask the witness to stress that when they go back on the record, and that's what they did. He didn't change his testimony. He didn't tell him to change his testimony, as Mr. Perlman suggested. What does disturb me about this entire matter is that a secret conversation between an attorney, their expert witness, and a client was filed in the court file in this case without any prior ruling by anybody as to whether it was privileged, whether it was work product, whether it violated the wiretapping statutes. The appellant filed that recording and is now claiming, even though it's a matter of public record now, it's in the court file, that because we reference it in our motions, we therefore waive any of these privileges or arguments that appellee could have. That's similar to a criminal case where you move to suppress a confession, and then the other side says, well, you've now waived your right to suppress it because you called it a confession and you've identified what was said in the communication. So we can argue that recording should be suppressed, and then also in the alternative say, but even if it were allowed in, it's not a confession anyway.
Were the bank statements that I referenced earlier part before the arbitrator?
Yes, and they were filed in the arbitration proceeding. I absolutely know that to be the case. They were in the record in the arbitration proceeding, and
so there was an option to cross-examine as to the 2014 distribution.
Absolutely.
As to who for statute of limitation purposes.
Not just an opportunity, it happened.
I read the testimony.
Yeah, it actually happened. The expert witness was then crossed by counsel for Lawson on the dates of the distribution and made sure that the arbitrator knew that the money wasn't paid to the claimant in the arbitration, but to actually the ultimate beneficiaries. I mean, that was all brought out and was known to the arbitrator. And I want to talk about things that happened that we're bringing up today and discussing that were actually raised at the arbitration or could have been raised at the arbitration. Number one, there's an argument that was made that it was improper for the attorney to speak privately with the expert witness during a break in his direct testimony. But the fact is that the parties all knew that this meeting was taking place. The attorneys for Lawson knew that there was a meeting going on with the attorney, the expert, and the client during a break in testimony. When they went back on the record, the attorney didn't say, the attorney could have said, did you just have a private meeting with Mr. Fittipaldi? And if so, what did you talk about? And the reason why I say he could have done that is because at that point, Mr. Fittipaldi could have waived the privilege. He could have allowed the testimony to continue, allowed him to talk about what they discussed. Or he could have said, objection, it's attorney-client privilege, it's work product. He could have raised those objections. And then the arbitrator would have ruled on whether or not that conversation was privileged. But there was no effort made to do that at the arbitration. If Lawson was concerned that there was improper coaching, he could have raised it by asking those questions. If he was concerned that they even had the meeting, Lawson's attorneys could have raised the issue and objected to the meeting privately during a break in the testimony, but they didn't do that. And the rule of this court is not to make findings on issues that are subject to arbitration, but never raised in the arbitration proceeding. There's also this argument that the arbitrator exceeded its authority by entering the award because the statute of limitations had expired or because the distribution was ultimately made to the beneficiaries. But these issues were raised there, and maybe the arbitrator made a mistake on the law, but the rule of this court is not to now review the legal decisions of the arbitrator. In the Schnurmacher...
Is there any remedy available to a party if an arbitrator enters an award that is not supported by the evidence?
Well, absolutely, there are very limited... I'm not answering that question because the evidence is not in dispute. The question is the interpretation of the law.
The position of the other side is that the wrong party, no standing, and so forth.
Right.
So for the sake of argument, if in fact that was established conclusively at the arbitration and the arbitrator just got it wrong, didn't understand the evidence, entered an award that wasn't supported by the evidence, is there an ability to challenge that?
I don't believe so. And I'll tell you why I say that. Section 682.12, which is the Paren 1, lists the grounds for vacating an arbitration award. And there are only 4 grounds for doing it. Number 1 is partiality or other misconduct prejudicing the rights of the party, and that's partiality by the arbitrator. Number 2 is the arbitrator exceeded its powers, and I'll get to that in just a moment. Number 3 is refusing to hear evidence or refusing to postpone an arbitration when there are good grounds to postpone it. Or number 4, there's no agreement to arbitrate. Those are all the only standards for setting aside an arbitration. And in this case of Schnurmacher Holdings, which is a Florida Supreme Court case, the issue was raised that the arbitrator exceeded his powers by entering an award that wasn't supported by the evidence. And in that case, the court said that that's not failure to apply the evidence and follow the law is not exceeding the power. The exceeding the power would, and actually I have the case right here. Let me just read to you what the critical point. Our view is that an arbitrator exceeds his or her power when he or she goes beyond the authority granted by the parties in the operative documents and decides an issue not pertinent to the resolution of the issue submitted to arbitration. So, and it says it's not an exceeding power if the arbitrator departs from the accepted rule of law, and that's not a basis for exceeding its power. So as long as the arbitrator had the authority
But
to...
if the arbitrator were to get it totally wrong,
Correct.
there's no remedy unless you can establish with evidence partiality by the arbitrator, corruption, or some other type of misconduct that goes beyond the evaluation of the evidence and the application of the law.
Absolutely, and that's very clear by the law, and that's...
So there's no second bite at the apple to argue standing for the trust.
Exactly. As long as the
is
trust was a party to the arbitration
correct.
agreement, which they were,
And that argument was obviously,
disposed of
yeah.
by the arbitrator. And this is the risk of going to arbitration. And I'll say that since I think it was 1982, Merrill Lynch first started putting these arbitration clauses in securities, all securities agreements. You cannot open a brokerage firm in the United States that I know of with any brokerage firm.
Aren't they required by FINRA now to...
Have an arbitration?
Yeah.
Well, no, that's a good point. FINRA requires that that brokerage firms arbitrate all disputes if the customer requests it. If a customer does not request it, they can go to court if there's no arbitration agreement. But you cannot open a brokerage firm account in the United States, as far as I know, without signing an arbitration agreement. It's in every opening account agreement. And that's the risk that brokerage firms take. But they decided to assume the risk by insisting on these arbitration clauses. Your Honor, I heard what you said about being disturbed by the communication between counsel, but between counsel and the witness. And as I stated earlier, I know Mr. Fittipaldi, and since he did not ask the witness to say something improper or say something that was not true, I would submit that asking a witness to stress a fact to an arbitrator is not improper, but reading it the way you read it and the way that Mr. Perlman characterizes it, it's worse than it really is. And I do feel that the court was correct in suppressing the recording because there was testimony, I want to point this out, there was testimony at trial by Mr. Fittipaldi that he did have an expectation of privacy when they were in that room, that there was no reason to believe that their conversations would be recorded, and this statute 934.06, I don't think I cited it correctly in my brief. I think I cited 934.03, which is the wiretapping statute that makes it a crime, but 934.06 specifically says whenever any wire or oral communication has been intercepted, no part of the contents of such communication and no evidence derived therefrom may be received in evidence in any trial, hearing, or other proceeding in any court. And there was a horrendous decision of McDade versus State where the court found, this went to the Florida Supreme Court, where a minor child recorded a conversation with her stepfather, sexual abuser, and that recording, because the stepfather didn't know about the recording of the conversation, the recording was suppressed, and so that's a rule of law that this court just needs to follow in every case of an intercepted communication. In this case, the interception was inadvertent. There's no question, it wasn't intentionally done for this purpose, but it's the use of the conversation, not the circumstances surrounding the interception of the oral communication that's important. It shouldn't have been admitted into evidence. And also, it's our position that the court was correct in suppressing it for another reason, and that's because it's work product. Work product is defined as the personal views of an attorney as to how and when to present evidence, his evaluation of its relative importance, his knowledge of which witness will give certain testimony, etc. And in this case, the attorney stressing to the witness the importance of pointing out the date of a distribution made out of the bankruptcy proceeding so that it wouldn't be lost on the arbitrator is work product. And now, work product we typically evaluate when we're thinking of, well, should something be disclosed in discovery or is it work product? And I would say that it's not the fact that they got this work product after the arbitration award was already entered doesn't make it any more admissible than it would have been earlier. For instance, if an attorney makes notes about, which constitute work product, and it's not discoverable after the verdict is entered, all of a sudden the attorney's notes don't all of a sudden become discoverable. So it was properly suppressed as being work product. The court also had serious concerns about whether it was attorney-client privilege, and expressed in Judge Stevens' opinion that it was attorney-client privilege because of the fact that the expert who testified, there was testimony from Mr. Fittipaldi, he was actually hired as an expert to assist him in preparation of the case. So, number one, the trial court was correct in suppressing the recorded conversation. Number two, even if it had been permitted into evidence, it wouldn't have made any difference because the witness didn't testify falsely. And even if the arbitrator made an error of the law, and I'm by no way conceding that the arbitrator made a mistake when it comes to the law, but I'm just simply saying that it's too late to argue that point. It's too late now to go back and revisit it. And for these reasons, the appellee respectfully requests that this panel affirm the judgment of the circuit court denying the motion to set aside the arbitration award and grant the appellee's and affirm the decision to confirm the arbitration award.
Thank you, Mr.
Thank you.
Mr. Perlman, you have a couple of minutes.
Thank you. Thank you. I'm going to need them. With regard to the recording, I think the record's clear. Judge Stevens denied the notion that it was protected under work product. I'm not sure why Mr. Luden said the contrary. And there is no way it could be protected under any of the claims, including the wiretap statute, because that requires a showing of an expectation of privacy. And on cross-examination before Judge Stevens, Attorney Fittipaldi confirmed that he was aware that a testifying expert would have to reveal what was discussed. That's how it works. And at trial, the wrong case was cited to Judge Stevens. The other side cited the Jenkins decision, a Seventh Circuit case, for the proposition that it's protected. And what they left off was the next sentence in Jenkins, which said, that's true for consulting, as we know it, but that's not true for testifying. And as we all know, this expert was a testifying, not a consulting. A. B. Mr. Luden said he didn't change his testimony. That's not accurate. And I cite records 61 and 62. This is when you go back on the record right after the secret caucus. Mr. Deinhardt, now we're going to have you testify with respect to damages. Before we continue, you stated previously that the last distribution in the property was in 2009, which is true. No, I said 2010, and I was incorrect. It's 2009. Question, okay. Answer, September 2009. Question, because he's obviously not getting it from their powwow. Was there a distribution subsequent to the property's bankruptcy? Answer, yes, in 2014. He did have him change the facts. He did change his testimony. It's on the record. Now, to your question, there is recourse. There's two forms of recourse. And the law, and it's not as developed as I would prefer, granted, but it would still allow this court to hang its hat on it. And the two bases are, A, exceeding an authority. Now, in all these cases, the facts and law are in dispute. And you can't challenge if the arbitrator gets it wrong. I get that. But when it's overwhelmingly one-sided, there is no dispute. It would be impossible for anyone on this planet to suggest that this claim accrued in 2014, 6 years after the demise and destruction of the trust's interest in anything to do with this property.
And Mr. Perlman, you've got about 15 seconds to wrap up.
Judge, and I cite the Morgan Stanley case and in our brief DirecTV and Mills, but the most important point, Judge, is Bonner. Bonner is the fraud case. The fraud case is not the Florida Supreme Court case that he referred to. The fraud is the way here. The fraud permeated this case, and in Bonner, they had the ability to get that evidence. There was a lapse between the trial and the ruling of 30 days. They were on notice that this witness was going to testify. They could have performed due diligence.
And that takes us to the conclusion. So thank you, counsel. We are adjourned.